Can we all be seated, please? Good morning to our online audience, and also good morning to the members of staff and our friends and colleagues who are visiting us this morning. Good morning to all of you, and thank you for being here. I would just like to make an announcement with regards to health and safety. In the event, unlikely event of a fire, the fire escapes will be via these doors on the sides, and the door on my right or your left. You go out via this door and you turn left or you walk left. On this side, to your right, you go out by that door and then you walk to the right down the stairs. That's where the fire escapes are. Okay, thank you very much. We will start immediately. The word of welcome will be done by Dr. Bongani Ndlovu, who is the Executive Director at Iziko Museums. Thank you. Over to you, Dr. Ndlovu.
Thank you, Mr. Arnold, facilitator for this workshop today. Thank you also for your close reading of the Act, the POPIA, and your keen interest in trying to get a deeper understanding of the implementation issues embedded in the Act. Chairperson of Summer Training Committee and ICOM South Africa President, Ms. Catherine Snell, ladies and gentlemen, colleagues, welcome to Iziko Museums of South Africa, and welcome to POPIA for Heritage and Museums, Compliance and Exclusions for the Sector workshop. The question is, why are we gathered today to look at POPIA for Heritage? I think that's a critical question for us as we try to engage and get a deeper understanding of the Act. Iziko Museums, SAMA, the South African Museum Association, and ICOM South Africa realized that there were a number of challenges for the sector in the implementation of the Act. And all of us were trying to find a solution to these challenges. We were looking at the unintended effect of the Act to the core functions of museums, and particularly also the negative effect that the Act or the interpretation of the Act was beginning to have for the sector, and also for the implementation of our mandate, particularly also heritage preservation and promotion. And we wanted to explore these exclusions and compliance issues in more details. We engaged the Department of Sport, Arts and Culture on some of these challenges. And Advocate Maake, I'd like to thank DTG Mdima for allowing you, sir, to lead the discussion today. We also extend our warm welcome to you, and also for allowing time to join us and explore this. We are grateful that we are able to allocate time for us. We know that you understand the sector very well. In fact, we can, with caution, say you are the child of the sector. But not only that, you understand the legal framework, you understand all other pieces of legislation that guide us and govern us. We are positive that with your guidance will emerge better practitioners today. Mr. Arnold has indicated and welcomed our online colleagues, participants, and we are glad that they are able to join us virtually today. Colleagues, once again, I welcome you to Iziko Museums of South Africa and to POPIA for Heritage and Museums Workshop. Thank you.
Thank you very much, Dr. Ndlovu, for that welcome. Um, I would now officially like just to run through the program, but also to introduce myself. My name is Hilton Arnolds. I'm the Director for Education at Iziko Museums of South Africa. The reason why we are meeting here today is to explore our theme and also the title of this workshop. It is titled POPIA for Heritage and Museums, Compliance and Exclusions for the Sector. So after that welcome, and now the introduction of this program, which will run as follows. We will start off with about an hour or so presentation by Advocate Dennis Maake. And you heard his biography a few minutes ago. He will do a PowerPoint presentation, and soon after that, we will move to an interval, as you can see, online on the program. After the interval, we will then explore the Act itself. We will actually go through the document, and then we will look at some of the sections and subsections and paragraphs in the Act. So we will try to explore, we will explore that. And during that time, we will take questions from our audience. Soon after that, we will move over to Ms. Catherine Snell to do the vote of thanks, and that will close the proceedings. So I will just start to say why we are here. Personal information. It's become quite easy to access people's personal information. It's become quite easy to manipulate people's personal information, to delete it, to abuse it, and to use it for all sorts of maybe nefarious activities. As an institution, we deal with people's information in various capacities. We use information for research, we use it in terms of human resources, and it's important that we take care of people's information. If an institution or organization is negligent with people's information, or if workers are reckless in working with handling people's personal information, then a company or an organization, the museums, the heritage sector organizations, we could be held liable for negligence. Furthermore, it could also impact on the business relations that we have with our partners, and therefore understanding the POPIA Act, Protection of Personal Information Act of 2013, we need to work with the document. It's important to know that the POPIA Act is not a standalone act. It interacts with other documents and other acts. It interacts with the Constitution firstly, and the Constitution allows us to privacy of our personal information. But at the same time, there's another act, the POPIA, Promotion of Access to Information Act, which again allows access by the public or by private individuals to access certain information, especially public information. So we are here today to see how all these acts, not only those two, how all these acts and the Constitution work together, and what our role is. How do we navigate that? I would like to just say that it is the responsibility of every worker in an organization and institution to take care of people's personal information. Also, the information that's entrusted in them in their daily tasks, in their daily duties. So I will now go, so thank you for that. I will now go hand over to Advocate Maake for his presentation. Please do enjoy it. Advocate Maake, you may go ahead. Thank you.
Good morning, colleagues. I understand my biography was done in my absence, but that is okay. I just want to say a few words before I can start.
Advocate Maake, my
Okay.
humblest apologies. Humblest
Okay.
apologies. I'm going to read. I want to read Advocate Maake, Dennis Maake's biography to you now. So, Advocate Dennis Maake is an advocate of the High Court in South Africa. He serves as a board member of the Eastern and Southern African Regional Body of the International Council on Archives and head of its Legislative Review Committee. He further serves in the Legal Deposit Committee in South Africa, appointed by the Minister of Sport, Arts and Culture to advise the Minister on the deposit of documents and records as defined in the Legal Deposit Act. Advocate Maake serves in the Oral History Association of South Africa as an ex officio member. Advocate Maake is a former curator of the Maake City Museum and a member of SAMA. Internationally, he served as a member of the FIAF Executive Committee and the Africa Regional Committee for UNESCO's Memory of the World Committee. Advocate Maake has formal qualifications in law, labor relations, corporate governance, business, knowledge management, heritage, and archives. He has over 20 years of experience in managing heritage institutions in the country. He is currently employed as head of the head of National Film, Video, and Sound Archives at the Department of Sports, Arts, and Culture. Thank you very much for that.
Thank you very much, Mr. Hilton. Okay, colleagues, in addition to that short biography of mine, I would like to indicate that I was actually one of the members who were tasked in amalgamating the 5 museums which now constitute Iziko, and the museums in Gauteng, which constitutes the Zong, and the transformation of a number of cultural institutions in the whole country. Okay, I also stayed here in Cape Town for a very long time to establish what you now call SARA, which is, I think it's this way. Yeah, it's this way. Yes, I did geography when I was still young. And then Dr. Ndlovu, I've known him also for so many years when he joined the heritage field. He found me there already as just a shortangana and not young, short in height. Gentlemen. Okay, colleagues, today we are going to have a very interesting session on POPIA and dealing with issues of heritage, museums, cultural institutions as a whole, including archives, as to what is actually expected of us, what is it that we must do in order for us to comply with the legislation. I thought I was going to be able to also, because I see is here, going to also deal with issues of how internationally we are to handle issues of artifacts, issues of exhibitions whenever we take them abroad. But then I just want to caution colleagues here that I'm not going to talk about issues of repatriation, etc., of whatever has been stolen from this country. But then maybe during tea, we can also engage on such matters for me to be able to share my views on how we can handle such. Okay, I think the presentation is there now. You know, I was born before computers, so they gave me this thing to press. Okay, which way? Not this way?
Yes.
Oh, yeah. Okay. In terms of the table of content, we are going to talk about the purpose of POPIA, the implications of POPIA, and role players involved in processing or dealing with issues of personal information. Then we are going to then also deal with conditions of lawful processing. I just want to inform the whole house today that number 4 it's just okay. Let me see. Okay, it seems like the slides are not properly marked. Number 4 will be our anchor or our main topic for today, because in understanding this legislation, if you don't know the 8 conditions, then you'll get lost. You have to ensure that you understand the conditions, because those are what is needed for you to navigate through the whole legislation. Then we'll then talk about issues of compliance, then implementation of POPIA. Then we'll deal with information officers and deputy information officers. Then their duties. Then we'll talk about risks in not complying with the legislation. Then we'll talk about the powers that the regulator has in enforcing what is required of us. We'll deal with issues of complaints. Then lastly is that a big issue that everyone is actually trying to ensure that is avoided. That is to deal with penalties, which are like so hefty. In my whole life, I've never even earned that kind of money, which is the penalty for anyone who will transgress this legislation. Then lastly, we'll then go to conclusion. And as the MC for today indicated, we'll then have questions, and yeah, then we'll be done for the day. Okay, then we move by indicating that Section 2 of the Act gives effect to constitutional right to privacy, as the MC indicated earlier. This is done by safeguarding personal information when processed by a responsible party. I will come back to the issue of who is a responsible party in my talk. Subject to justifiable limitations, and that are aimed at balancing the right to privacy against other rights. If you look at the Bill of Rights, there are like lots of rights that are put in there, and we all know that those rights are making us as South Africans in particular to be what we are. And these particular rights, particularly the right to access to information, you know that that right is there in the Constitution under Section 32, and protecting important interests, including free flow of information within the Republic and across international borders. You remember I indicated that since ICOM is here, I'll also like to touch on issues of how we'll deal with when we are getting exhibitions from international sister organizations, or we are taking exhibitions to those sister institutions in the whole world. But again, that issue of free flow of information, you'll see in the Act, it's written there under Section 7, which Section 7 that deals with issues that journalists are having a right for them to be able to report without any hindrances. It is okay on page 27, which says exclusions for journalists, literary and artistic purposes. So that free flow of information deals with that to say no one will be gagged, but whenever one processes information, one has to be conscious of the fact that there may be some personal information that does not need to be disclosed. Okay, I'm reading from here, but okay, yes, yeah. Maybe from here. Okay, then also still under section 2 of POPIA, we are saying that section regulates the manner, or the act itself regulates the manner in which personal information may be processed by establishing conditions. You remember I spoke about 8 conditions. We'll come to that as we continue. And those conditions needs to be in harmony with international standards. For us, it is important to take note that this legislation was not just passed by our parliament, but there were like international benchmarks that were made to check as to how other progressive countries are progressing in terms of putting together such privacy laws. And that section also of the Act also prescribe the minimum threshold requirements for lawful processing of personal information, meaning that we cannot just put the bar very high. We all know that sometimes it happens that if the bar is very high, it happens that we may have transgressors unintentionally, but then the Act ensures that there is just a minimum threshold that needs to be met by all of us. As you know, that protection of personal information is not only confined to corporate, but is also confined to personal one-on-one relations. As my colleague the other day, we were discussing a few case laws, and we came about the SMARTS case, which involved issues of Facebook, whereby one colleague disclosed personal information of the other, took photographs of young children, etc., addresses of that individual, and posted those in the website. And the courts ruled that that is one of the things that don't need to be done. It's against the law, as it exposes people to risk. Then the legislation also provides persons with rights and remedies to protect their personal information from processing that is not in accordance with the law. And lastly, okay, and this section of the legislation establishes voluntary and compulsory measures, including the establishment of the regulator. The regulator is somewhere there in Johannesburg, in Braamfontein, and the Act also ensures that there is respect for and there's promotion, enforcement, and fulfillment of rights as protected by the legislation. POPIA applies to personal information entered in a record by or for a responsible party by making use of automated or non-automated means, provided that when the recorded personal information is processed by non-automated means, it forms part of a filing system. We all know that in organizations, we have various filing systems, and we have also records management, etc., and also is intended to form part thereof. POPIA, as it is, takes precedence of over other laws that regulates processing of personal information, which are materially inconsistent with POPIA and does not prevent a public or a private body from exercising such rights. If you look at the back of the legislation, which a copy has been provided to us, you will see which legislation have been amended that you'll find in the legislation just after schedule laws amended by section 110. laws such as the Public Protectors Act, sections of that act were amended to comply with this. Also, the Public Protector and you will remember that there is the ICT legislation. The ICT legislation is the one that we are currently using whenever we are working remotely, and we can be able to append our signatures, and those signatures are, according to law, enforceable to say that action that you have put forward is actually binding. That you'll find in 152 is the Electronic Communications and Transaction Act of 2002. Also, the National Credit Act. Those are the three. But then, as indicated that I work for the archives, we from the archive side, we are saying maybe we need to have a discussion with the regulator so that we can deal with a number of issues, specifically that our act or none of the provisions of the National Archives Act are like been amended by this act. But then the regulator is saying that any other act like POPIA, for example, National Archives Act, the three legislation I've just mentioned are like a junior to POPIA. Okay, then I indicated that we will deal with the role players, and I am committed that I will explain what is a responsible party is. So in this slide, we are having such definitions as to who is who, and then you'll get that in the definition section of the Act, which is on page 13. And what is important now is that we need to know as to what role does each of these people play in administering this legislation. We are saying data subjects and their functions that is person to whom information relates, meaning that when, for example, you have conducted oral history recordings with the people in former Transkei, for example, then the data subject will be that informant in the heritage sector, or also in science. We call such people informants, meaning that the people who are carriers of that information. Then the responsible party is a public or private body or any other person which alone or in conjunction with others determines the purposes. Okay, their function determines the purposes of a means for processing personal information. Then we have an operator, and the duty of the operator is that of processing personal information for a responsible party in terms of a contract or a mandate without coming under the direct authority of that party. Then we have a competent person, and the duty of a competent person is that this is any person who is legally competent to consent to any action or decision being taken in respect of a matter concerning a child. You will have heard several times people talking about that we need to protect identities of children against any other unlawful processing, or that children needs to be protected, etc., etc. The reason for that is that you know that there are like limits in terms of what a child is and what a child can consent to, and those issues. As such, we are saying that a competent person must ensure that there is respect for matters concerning a child. Then we can go now to this lovely part that I like, which is the conditions, as I indicated to you earlier. We have 8 conditions. Condition number 1 is accountability. Condition number 2 is processing limitation. Condition number 3 is purpose specification. Condition number 4 is further processing limitation. Then condition 5 is information quality. Then condition 6 is openness. Then condition 7 is security safeguards. And the last one is data subject participation. Here, colleagues, you'll see in the Act, in terms of issues of accountability, the regulator is saying that people or corporates, they need to be accountable in any actions that they are taking whenever they are dealing with the processing of personal information. This, in a sense, means that one does not need to be reckless in handling personal information of others. You need to know that there will be consequences if you are irresponsible in processing people's data and personal information. Then under processing limitation, which is condition number 2, the regulator is actually saying that whenever you are processing information that this has to deal with issues of section 14 of the legislation, is that if, for example, an employee, a prospective employee applies for a job here in Iziko, and that person does not become successful in the job, what then happens is that the employer, which will then be Iziko in this instance, does not have to keep the records of that prospective employee in perpetuity. There needs to be a limitation to say, okay, where I come from, normally when we deal with HR issues, we say that an applicant's information can be kept for a period of 1 year, and it depends from organization to organization. But then something else again under condition number 2 is that whenever you are accessing a public building like this one, and the security, they take down the details, it is not necessary for them to also try to ask me whether and that Maake, are you married, and those kind of things. Those are actually okay, maybe if I can use just a loose way to say that that will be none of their business. What they need to only process will be that Dennis Maake, I'm coming to visit Mr. Arnold. And then that's it. Maybe my phone number, so that should I get lost in this building, then they can be able to trace me, or if anything happens, there's a disaster happening, they can then be able to trace me. But then they don't have to like ask me like in the location where I come from in Soweto, we call it a Basale special, meaning that any unnecessary information. Then condition number 3 deals with, it says it's purpose specific. It means here that there needs to be a purpose, and then that purpose needs to be specific as to what is this information that is required of me is all about. It ties in with number 2 to say if the information that needs to be disclosed or limited is like above bounds, then that is out. And then condition number 4 deals with further processing limitation. Further processing limitation deals with issues, for example, that if I come and attend this workshop and I fill in a form to say Iziko can contact me if similar workshops are happening, etc., then they can contact me at this number, etc. So it means that information that they gathered from me when I entered here, then it will be further processed, meaning that there will be other things that they are doing, telling me about future exhibitions, telling me about other events like these workshops, etc. But as you know that everything that is to be done must be minimal, meaning the Iziko need not now come and tell me that there is this insurance company that deals with 1, 2, 3, and since I'm a heritage worker, maybe I may be interested in that. So there is that limitation. Then when it comes to information quality, here we are saying that if ever information quality is, it means that if Iziko is doing exhibitions, etc., whatever information that they are bringing to the public sometimes needs to be censored for particular reasons. And then sometimes that information needs to be put bare out there for everyone to know that Dennis Maake was a dictator in 1940 and so on and so on. But then the sanctity of the information need not be misconstrued in such a way that it now gives another meaning that, for example, the example that I was giving Mr. Arnold when we were having a discussion was that if you are putting together an annual report and you have photos of children or participants in a workshop, etc., and some people will want you to blacken the faces of some of those participants. It is a good thing, but on the other side, it's not a good thing because now the information quality will be lost. You need to provide reliable, workable information that you can give out to everyone. Then the issue of openness, you need to like be frank and fair in whatever that you are telling the story out there to say, maybe Chief Makana, is it Chief Makana who drowned in Robben Island? Yes. Yes, you need to be frank to say maybe what is the actual story, etc., etc. But then you don't have to now come and spice up a few other things, etc., etc. So openness, it is very critical. Then with security safeguards, we know that we have hackers, we have people who normally hold organizations hostage, and some also steal company information, including staff. Sometimes they steal company secrets and sell them to opponents, etc., etc. I know in the museum sector and heritage that is not prevalent, but in these big companies, you'll see that when one exits an organization, then there is that bar to say this person cannot work in this industry for a period of a certain number of years. Is to deal with that those company secrets. But then in addition to this is that it is important that we have our IT systems, for example, our login details, we change them. I think where I come from normally is monthly. You have to have a new password so that you can't have anyone unlawfully accessing the system of the organization. And also just a small thing, if, say, for example, I'm coming here to this workshop and I have a memory stick and I ask Mr. Arnold that please print us 4 copies of this document so that I can do my presentation. That also in itself is a breach. It's a security breach in that I may be coming with a virus. Say, for example, I'm from Ditsong and actually I'm a competitor to Iziko. Then I come with the virus. It's an example. I come with a virus so that I can crash your system here, and then my organization can then prosper in the eyes of the public and the world. So whenever you are putting together a security, you are putting together security safeguards, those are the things that you need to look at to say, if a visitor comes here and wants to print something, there are lots of internet cafes somewhere there where they can go and get assistance and et cetera, et cetera. And, but then, you know, some other issues are on case by case basis. You know that I work for the department that is paying or sponsoring this institution. So if I come with a memory stick, I don't have any ill intents on my head or in my mind. So I won't do anything wrong. But then if any Tom, Dick and Harry just comes in and wants to do those printing works, then that in itself becomes a problem. Then in terms of condition 8, it talks about data subject participation. Data subject participation deals with instances where, for example, I'll use oral history again to say, when we are mounting an exhibition, okay, there was a very nice exhibition here in this institution about the Koisan, etc., etc. I said it was nice because it was very controversial, and so on and so on. But then what is happening is that those data subjects, they actually have a right to participate in how the story will be told, and they must in a way approve also the way in which you are portraying that story. In essence, this means that you can't be putting a story about myself in a bad light while you have access to me. If you have access to me and then I'm the one who was the carrier of that information and I gave it to you, you must ensure that I agree. In the journalistic sphere, they call it a right of reply, those kind of things. So you can't just come and then put whatever there without my participation. I must probably approve the script to say, okay, yes, more or less, this represents what I've said to you, or what is happening about me and my condition, etc., etc. As indicated earlier, is that when all these 8 conditions are met, then it means one has satisfied the act, meaning that if you do anything outside this 8, then you are off, and then you can be liable for contravention of the act, etc., etc. So I think we all agree that these are like straightforward. They are bare minimum. They mean that in whatever that you are doing, you just need to be accountable. You don't have to offend anyone, etc., etc. And when you are processing information, it must be to the bare minimum, and then there must be a purpose. And when you processing the information further, you must get my consent. I must agree that yes, you can go ahead and invite me for other exhibitions or other things, and that the information that you are presenting to the public and the world and everyone else is of such quality in that there are no distortions. There's no one who can take legal action against you for defaming them or any other thing. And then you are open, you are frank, you are fair in your presentations, and that if I give you information and I indicate that there is an embargo, you'll respect that embargo to say I'm giving you this information. You can only now maybe also talking about issues of copyright. You can only release such information after 50 years have passed on, or 10 years, or whatever, based on the condition that I may have given you. Then you agree to that, then we are fine. Then the data subject must at all times participate in whatever that we're doing. Okay, colleagues, then now we move to the next slide. We're still dealing with issues of the conditions, is that all public and private bodies must put systems and processes in place to ensure compliance with the conditions for the full processing of information. That strengthened what we just went through, those 8, to say you must have a system. Other colleagues, they call it a framework. You can call it any other thing, but you must have a manual of some kind to say how you as an organization are you going to be dealing with processing of information. And that includes, okay, these the 8 conditions that I've already spoken about. And this includes activities and processes to be undertaken to implement each conditions, meaning that if you look at the Act, they indicate as to what accountability means. And there are various smaller steps beneath that, which says that in terms of accountability, what standard one must meet. And you go to all the other 8, they also indicate that what is it that you can do and what is it that you cannot do. If you have such a manual, you workshop it with all the staff members. You can also workshop it with your clients at any other given time, so that they know as to what is expected of them at any other given time whenever they are having contacts with you. And then you need to do a data mapping exercise. You need to do a data mapping exercise. This means that the responsible party must compile an inventory of personal information in its possession. This one actually is in both ways. One, it can be HR related. And secondly, because this is a cultural institution, this can be with regards to exhibitions that you are having. You'll know that if you have a photograph of a child, you cannot disclose all information about the child. That child then is 7 years old, is medically handicapped on 1, 2, 3, etc., etc. That is of benefit to who? It's not benefiting anyone. Just indicate that this is child Dennis Maake, 7-year-old, is good in public speaking, for example. Then you leave it at that. Okay, then in whatever that we are doing, we need to have a distinction between personal information and special personal information. This part about special personal information has to do mostly when you're dealing with children, because you'll know that in terms of Section 50, any organization needs to make an application to the information regulator when they want to process information regarding children. So personal information can be for any other person, but when you're dealing with children, it's in terms of the Act, it's called special personal information. Then you must also audit processes used to process personal information. Then you must know persons who have access to personal information and how and where such information is stored. Meaning that as an organization, what you need to do is that okay, let me talk about in government. In government, we have various levels of allowing a person to access information. We have confidential, which it's a bare minimum, which everyone working for an organization must have. Then we have secret, meaning it's a level above, whereby one can know a few secrets about the organization. Then we have a top secret. You'll have heard from time to time that some people, when in government, they don't have top secret clearance, then they are not having a right to be employed in some positions. This means that even in this organization or any other organization, you must have a system like that, whereby they are very sensitive information handled by any other organization, and those sensitive information cannot be known by everyone. Then there are secrets that are like to a little minimum, which can be known by a certain category of people, and then there is confidential information. But with that being said, you all know that no one can just, as an employee of any organization, go and disclose company secrets, like I said earlier on. So there must be that kind of a thing. But then here you'll be having, remember now we are dealing with what is it that a responsible party needs to do. You have that system which indicates employee X has access to such and such information, employee B, employee, etc., etc. Then all institutions need to ensure that appropriate security safeguards are in place to protect the integrity and confidentiality of personal information. In the organization where I come from, I'm at the archives, and then you'll know that at the archives, we do have, for example, records of former prisoners. We do have correspondences which people of interest or former prisoners, etc., were writing to their relatives, etc., etc., and responses thereof. And again, in addition to that, what the state at the time wanted to shield some information regarding probably whether what in one film I saw, when you have categories of prisoners, then some groups had privileges of wearing a long pant, trouser, and others short, etc., etc., those kind of things. So now, since that we are in a democratic country, we don't have to like, we need to be open as indicated earlier, but then in our openness, we must also ensure that we safeguard the dignity of those people who were involved, etc., etc. But then here, what I'm saying is that if all information that you are having, you will categorize it as secret, top secret, and confidential, as indicated earlier, but then also have various vaults or storage areas where you know that if you have a cabinet, as it was indicated in the media from time to time, that cabinet minutes are very confidential, etc., etc. No one can know about those other than those that are working with that. So in an institution, you can have those minutes of the board, for example, maybe just to throw a controversial aspect to say when they are dealing with sensitive information like salary increases, then that kind of information can be kept separately from can be kept separately from it is an example, it's an example but then it must be kept secretly somewhere in a vault which is different from where you have your normal filing system where you'll have a correspondence to say, Advocate Maake, you are requested to come and address a workshop. So you can't be having that information in the same file. Okay, that was to ensure security safeguards. Okay. Then the next one is that the responsible party, you'll remember who's the responsible party. If you look at definitions, there they'll indicate who's the responsible party, meaning that organizations must put in place a compliance governing structure. And depending on the size and complexity, appoint POPIA champions in the various strategic departments. What this means, sorry, colleagues, is that we need to know how to handle whatever information that we are having in the organization, and also have champions, people who will talk to segments of staff members to say why we handling issues of personal information in this way and not that way. People who will go to people and get them to have a buy-in in whatever management is doing. Then the responsible party must have policies, and such policies can deal with issues of retention, destruction of records and information. On this one, what the regulator is saying is that we need to have policies. This now comes to that issue which I spoke about earlier, whereby I'm applying for a position in this organization, and I get accepted, and there needs to be somewhere in the policies where it's written how long will this information about myself be kept by the organization. Then if I'm rejected, there must also be a policy which guides as to when such a record can be discarded. Because you will know from various quarters that for example, archives or registries in all organizations are full of records, and some of those records can be ephemeral. Normally, people in records management will tell you that ephemeral records have a lifespan of this number of months, etc., and then thereafter you need to discard those. So it is important that there needs to be policies generated by any organization, including Iziko. And then we are saying POPIA training is paramount. Today, okay, it's a workshop. Workshop forms part of training. So we are engaging with the legislation, but then this does not mean it needs to end today. It means constantly people must be trained on how to understand obligations of the responsible party and the rights of data subjects. And the responsible party must ensure that information officers and deputy officers are registered with the regulator. I will come to section 55 and 6 later on, but then in an organization, automatically the CEO becomes the default information officer. And then thereafter, in various sections, the organization can delegate members to be deputy information officers. And when I come to that section, I'll indicate what are the duties of these two very important people. But just to say again that, or stress that it is not a must that you must advertise and get a person who will be a deputy information officer or an information officer. Within the organization, you delegate various heads of sections, people with responsibilities to take care of all what is expected of information and deputy information officers. In order to assist responsible parties to comply with POPIA, the regulator has developed a number of guidelines and guidance notes. The There is a code of conduct that has been generated as an example on how the whole industry needs to operate, and that has complies with section 60 to 68. In the heritage sector, we have not yet done this code of conduct. We are in discussions with the information regulator that we need to have a workshop with all archives, libraries, museums, and heritage institutions, so that they can workshop us on how to generate such codes of conduct. And this code of conduct will then be used or will guide all employees of the sector as a whole. We all know that we as the knowledge managers, information managers, heritage and cultural workers, we fall under one group, which will be archives, museums, libraries. So our thing is that we are thinking that we must have one code of conduct, because okay, we like in any way dealing with like a structured way of dealing with the preservation and long-term use of the heritage of the country. Then there is also the guidance note on information officers and deputy information officers, and that deals with who the information officer is, the duties, and then there's also a portal that has been put together by the information regulator. And then you know that as my colleague indicated earlier, that in addition to POPIA, there is also the PIA, which is access to information, section 32 of the Constitution, and then that the information officer or deputy information officers that earlier, before POPIA came into being, you registered as information officers, then you can register the same people as functionaries who will deal with POPIA. Then there is the guidance note on prior authorization. This, as indicated earlier, is with regards to section 57 and 58. Here is that if you remember, I said there is personal information, and then there is a special personal information. If you are to deal with special personal information, meaning information about children, you need to apply to the regulator, and the regulator will then give you that authority on how you can go about processing information about children. Then there's a guidance note with regards to exemption, which exemptions are covered by section 36 to section 38. Section 37 deals with private bodies, meaning private bodies like companies, etc., etc. And then ourselves here, we are covered under section 38 because we are performing a public function, meaning all government departments and entities like these ones, they'll get exemptions under section 38. And what this means is that as long as you have complied with the 8 conditions, you don't need any other thing else as a public institution. But then as a private body, it is a must that you must know the act from page 1 to the last, etc., etc. But then even though we may be exempted under Section 38, we still need to provide reports, especially if there is any data breach. You have heard that there was a problem sometimes, I think it was last year, with Transnet and the ports in Durban, that the system was hacked and goods and everything was were unable to be delivered in the country because that whole system was like hacked by hackers from I don't know where, and a number of Asteria. You remember Asteria is this organization that deals with credit bureau or our information that Dennis Maake has bought a Pijo or this, etc., etc. But that information was then hacked, and then it was made available to some people, and some people were requested to pay some monies, etc., etc. So I'll deal with that issue when we deal with data breaches later. And if not, my colleague will alert me. Then let me just go back to that issue of Section 37. Section 37 indicates that public companies can apply for an exemption, and then that can be gazetted so that everyone else can know. But then when it comes to organizations like this one and any other cultural institution, we just have this blanket exemption. But my belief and thought is that even when we are exempted, what we need to do is that we need to formally write to the regulator. You say, regulator, we are Iziko Museums of South Africa, and these are the kinds of information we're dealing with. Information about historical facts, information about personal information that are held in our HR, finance, etc., like whoever got tenders and so on and so on and so on and so on. So then as we are exempted, we will in any case work with you hand in hand from time to time whenever some tenderers may think that we breached their information and will cooperate 1, 2, 3, etc., etc. And then there is the guidance note on processing special personal information. You'll remember that special personal information is the one that deals with children, and then it follows there. Then in terms of POPIA and POPIA and PIA, the head of a public or private body is by default an information officer. I indicated earlier that the CEO by default becomes the information officer, but even though it is by default, still we need to apply to the regulator for that designation to be confirmed. And then thereafter, you can then delegate or designate a number of deputy information officers. In organizations like this, you can have a head of education as a deputy information officer, head of IT as a deputy information officer, of HR, of finance, because all these people are dealing with various kinds of information, of research, etc., etc. Okay, then there is that portal where you can register these people online. And then now we come now to duties of information officers. Duties of information officers and deputy information officers are like similar because what then happens is that the information officer delegates those duties to the deputy information officer. And both those are covered under Section 55 and in Section 56. Okay, then their duties or their responsibilities are that of encouragement of compliance with conditions. How many conditions are there again? I want to see if we are still awake. Okay. Yes. The duties of the information officer or deputy information officer is to ensure that these conditions are adhered to. If that is done, then the information regulator is happy and there won't be any quarrels, any infringement of the legislation, etc., etc. Then the information officer or deputy, they deal with requests made to body present to POPIA, and then information officers or deputy, they working with the information regulators if there is any breach in order for investigations to be conducted. That is contained under Chapter 6. And then these information officers or deputy, they need to ensure that there is compliance, a compliance framework, and that compliance framework is developed, implemented, monitored, and maintained. What a compliance framework actually entails is that you'll see there where we were dealing with, it is on page 6. Where we're saying there needs to be a data mapping exercise done, there needs to be audits. That's what you'll have under that compliance framework. Then you'll also have information on who can access information and at what level. Issues of security safeguards to say Dennis Maake cannot access that information on salaries I spoke about, unless given authority, etc., etc. So that is what is being talked about under a compliance framework, is that the organization or organizations needs to develop that, they need to implement that, they need to monitor that and maintain that. By maintenance, it means if ever there are changes, there need to be alterations that are made. Okay, then it's compliance again. Then the other duty that these people have is that they need to have impact assessments needs to be done on the standards that are in existence and also on the conditions to check as to whether is everything under control. Are there data breaches? Are we processing information the wrong way? Are we getting personal information and passing it to third parties without informing the data subject? Those kind of things. Okay, then the information officer or deputy information officer cannot take that responsibility without being registered. So as soon as the information officer or deputy information officer has been appointed, there will be a letter from a certificate from the information regulator to say Dennis Maake is the information officer for Iziko as per the provisions of the Act, and then these are the duties that he must undertake, or if it's a she, these are the duties that this employee must then undertake. Then under risk,
excuse me, I'm sorry for this, Advocate Maake. I'd just like to make an announcement. From 11 o'clock, we will move from stage 2 load shedding to stage 4 load shedding. So this is the communication that we received now from Eskom, that we will move from stage 2 to stage 4 at 11 o'clock. Unfortunately, the area that we are in here in Cape Town and where the museum is located is in area 8. And from 11 o'clock, we will be impacted. We will be affected because of that load shedding. Advocate Maake is now on slide 9 or section part 9 of his presentation, and he still needs to do 9, 10, 11, and 12. We will most probably lose signal. This is to our online audience, by the way. We will lose signal, we will lose sound. We are monitoring the situation. However, this recording, excuse me, this recording is available on YouTube, and it will be available on YouTube. I just want to reiterate, I don't think we should try and rush the four parts it is 7 minutes to 8 minutes. So I don't think we should rush it. We're dealing with a legal document and legal documents. After Advocate Maake is finished, we will go into for a break interval, and then I will present, and we will deal with the act itself, the document itself. The online audience, everyone received the act, and you would see in the document that was sent to you, we've highlighted certain parts in yellow in that document. You are encouraged, please, to view the rest of this presentation and workshop online via YouTube, via our platforms, and to interact with the document. I think that's important. Advocate Maake is giving us an extremely in-depth introduction into the workings of POPIA in terms of the heritage sector and the museum sector, particularly in terms of compliance and understanding the POPIA Act. After this, we will deal with the document itself, and then we will look at the other half of today's meeting, and that is those exclusions, how we navigate our work. So I think to our online audience, who I assume are all from the heritage sector and the museum sector, please do download and watch the rest of this presentation so that you will understand and how you are able on your own to navigate your work using that document and the act. Thank you very much. We will proceed. Thank you.
Thank you very much, Mr. Chair. It's unfortunate that we'll be losing colleagues who have joined virtually, but as the chair has indicated, there is backup in that this presentation will be sent to you, and also the act was also sent to you, and there are areas that were indicated that you can look at. But before it hits 11 o'clock, maybe I can take this opportunity to give everyone my email address so that if we lose you, then you can be able to communicate with me. My email address is Dennis, DENNIS, M for my surname, at dsac.gov.za. So it is Dennis M at dsac.gov.za. Then you can send questions if we lose you, or if ever you are shy to ask questions today, you can talk to me privately at that. But if you didn't get my details properly, you can at all times communicate with the program director or the executive director. They can share such information. They have my permission. They won't be infringing my rights. Thank you, colleagues. Then in terms of risk, colleagues, what we are saying here is that non-compliance may result in offenses and administrative fees being imposed to your organization. And you'll also run a reputational risk that non-compliance will also result in a reputational risk for an organization. But then this may be managed by ensuring that your compliance structure comprising of POPIA champions. Remember, when we talk about champions, is that in each unit, you can delegate 1 or 2 staff members to be the mouthpiece of the organization, who will ensure that those 8 conditions are met, and then from time to time, you need to train those compliance or champions, and then you resource them, and then you give them a budget of some sort so that they can be able to buy suites whenever they are running smaller workshops, etc., or water and so forth. Then as an organization, you need, this is mitigation. You need to continuously monitor and evaluate compliance levels in the organization. And top management is actually called upon to ensure that it drives such a process. I've had a very interesting talk that I listened to yesterday. Currently, the knowledge management conference is taking place in Johannesburg yesterday and today. It was indicated there by the principal of the National School of Government that if top management lacks or does not communicate well, etc., that affects the whole organization, even lower down. So top management needs to ensure that they are also a part of the champions of POPIA to ensure that compliance is there on the 8 areas that we spoke about. Then in the legislation, section 73 to section 79, it deals with enforcement powers of the regulator, meaning that should there be any data breach, the regulator has powers to start putting systems into place, and later on it can also deal with issues on how they will handle issues regarding that data breach in terms of penalties, etc. So in this slide, we are saying the following constitutes interference with the protection of personal information of data subjects, in that if there's any breach of any conditions, you remember the conditions, those 8 ones, that becomes a breach. Then non-compliance with section 22, that is that issue of security. If there's a compromise in that, you allowed Dennis Maake to bring his memory stick here and infect the whole organization's server. Hackers can easily then penetrate this organization, and the information we are having, that will be a security breach. And then section 54, issues of confidentiality, if they are not adhered to, they constitute a security breach. Then section 69, 70, 71, that is a right of a data subject regarding direct marketing by means of unsolicited communication directories, automated decision making. Here, colleagues, you remember when I was saying, when entering this building and I fill in the form to say, I'm Dennis Maake, I'm coming to see Mr. Arnold or coming to attend this workshop. If this organization then takes that information and start giving it to third parties, that then becomes a security breach. I know I've given my email address to all of you, but I'm a public servant. I'm allowed to be contacted 24/7 so that I can be able to do a public service or render public service. But then that does not mean then now that Dr. Ndlovu must then now go to Mitchell's Plain and tell them that if you need information on POPIA, here's the email address. You'll be preaching these sections 69 to 71. I've given that information to all of you because you attended here, and then you may want further communication. Then section 72 deals with transfer of personal information outside the country. This section is the one that I was talking about to say if we are having exhibitions and as we are allowed in terms of the Cultural Institutions Act to have such loans being made to outside organizations, and outside organizations also bringing us exhibitions. If in undertaking that you transmit personal information to those people, you may be breaching the rights of the subject, the data subject. So you need to ensure that whatever that you are doing, you don't breach personal information of data subjects in conducting your business with sister organizations anywhere else in the world. Then in terms of complaints, here anyone can send a complaint to the regulator, and there's a form, and then you have to put in the allegations you are putting to say, I gave my email address to participants of this workshop. But then all of a sudden now Old Mutual is calling me every day saying, we know you're in Cape Town. Here is the insurance we are selling to you. I mean, that does not have to do with this workshop that we attended today. So then I can go and lodge a complaint to the regulator to say, hey, Old Mutual is pestering me, etc., etc., etc. Then a responsible party, meaning the organization or a data subject, myself individually, I may submit a complaint to the regulator in that form that I spoke about up there, where I indicate why I'm aggrieved, and the information regulator will then appoint an adjudicator who will investigate the matter. Then what then happens is that when a matter is referred, the information regulator may conduct a pre-investigation. Okay, in law, normally we have words like may, we have shall. Those are very important whenever you are reading any law, because may means it's not a force. Is that you are at liberty. So it means the regulator is at liberty to do a pre-investigation. And then the regulator will then be a conciliator between the various parties. And thereafter, they decide on an action that needs to be taken. And if it's a big thing like the Speria